you, Amber, and good morning, everyone. We're going to spend some time this morning talking about getting ready to implement the Connecticut Paid Leave Act and the Connecticut Family and Medical Leave Act revisions, which will take place in January, or will take effect in January of 2022. I am Mary Choquette. I'm the General Counsel for the Connecticut Paid Leave Authority, and I'm an a lawyer focusing on employment law by training. Just jumping straight into the agenda, we'll talk a little bit about our program, and then we'll spend some time just as a reminder, the difference between FMLA and CTPL. And then we'll really focus on what you can expect with the implementation of the Connecticut Paid Leave Act and what you need to think about as you roll out the implementation of the revisions to Connecticut FMLA. Then I'll share with you some additional resources. And as Amber said, we do have time built in for question and answers. Please use the Q&A function in Zoom. So, the Paid Leave Authority is a quasi-public agency. We were created by statute with the goal of establishing a program to allow employees who need to take time off from work to have access to income replacement so that they can focus on their own serious health condition or caring for a family member without having to worry about that lost income. In addition to providing those accessible benefits to workers, we want to make sure that employers, administrators, healthcare providers, really everyone who's involved with the leave process has an understanding of what their roles are and to make sure that they have the support they need. At the authority, we have several statutory responsibilities, including outreach and engagement, which is one of the reasons we do these educational webinars. And you may see us out at various events, races, fairs, festivals. We're trying to get out there. We had to start from scratch. So we're building up the agency as we're building up the program and developing the policies and procedures we need to run the program. As a quasi-public, we do not have regulations. We have publicly noticed policies. So for example, we are receiving public on our policies relating to private plans. And next week, we'll be issuing for public comment a revised employee handbook, as well as policies related to the administration of Connecticut Paid Leave. If you're interested in getting access to any of those policies, you can email me and I'll send them to you. We have to manage the money. So we established the contribution rate. It can be no higher than 0.5%. But in the future, if the trust fund is healthy, we might be able to reduce that. And we receive the contributions. As I mentioned, the private plan policies, there is an opportunity under the law for employers to offer their employees an alternative to the Connecticut Paid Leave program via private plans, either insurance plans or self-insured programs. They have to get approval from the authority, and we will audit those plans to make sure that the employees are getting what they're entitled to. And of course, we will be administering claims for paid leave benefits. We've been busy. Our website actually opened just about 13 months ago. Employer registration began just about 11 months ago, and employers started, or should have started, deducting the contributions from worker wages last January, and they should be doing that continuously. We've been reviewing private plans since February, and we've been receiving those payments. The payments are due on a quarterly basis, and we actually allow for a 1-month grace period. So, for example, if you haven't remitted your third quarter contributions yet, you're fine. You have until the end of October to do so. Starting in December, we will start accepting claims applications. We will not pay any money out until January. And the money will relate to leaves that are occurring in January. But people can get a head start if they want to submit their claims in December. And then starting in January, we will start issuing the benefits. The first question that always comes up is who is covered by the program? And the answer is almost everybody working in Connecticut. The definition of employer is really anyone who has one or more people working on the service of the employer in Connecticut. So that includes nonprofits. It includes household workers. It includes domestic workers. It includes private sector employers with unionized workforces. Sole proprietors and self-employed individuals can choose to opt in. So they are not required to participate for themselves, but if they choose to, they can opt in, and they'll make contributions based on their self-employment earnings. If they choose to opt in, they do have to stay in for 3 years. Although almost everybody is covered, there are certain groups that are not covered. The statute explicitly lists employees of the federal government, employees of the state of Connecticut, except as to covered public employees, which I'll define in a minute. Municipalities and local or regional boards of education are excluded unless they have covered public employees, and non-public elementary and secondary schools are also excluded, meaning employees of these employers do not contribute to the fund and cannot apply for benefits. There are also other laws which result in exceptions or exemptions. So, for example, railroad workers have a federal law which covers them, and so they don't participate in state programs. Similarly, individuals who are employed by other governments, so the governments of another state or employees of the sovereign nations, are excluded because our laws do not apply to them. There are 2 tweaky little exceptions that if you have them, you're probably already aware of them because those employees are not paying other state taxes. So employees who are engaged in interstate commerce, who work in Connecticut but live in another state. So think about an interstate truck driver who works out of Connecticut but maybe lives in Massachusetts or Rhode Island. They're not paying income tax in Connecticut already, and so they would also not contribute to the paid leave program. Very narrow exception, but important if you have those workers. Similarly, spouses of active duty military members who are deployed, or the military member is stationed here in Connecticut, but the spouse has opted to continue paying taxes in their home state instead of where they're currently deployed. So a spouse to someone who's stationed in Groton, for example, they don't pay taxes here, they pay in their home state, so they would not participate in our program. Again, if you have any of these employees, you probably already know it because they're not paying taxes. I promised you a definition of covered public employees. So a covered public employee is someone who does contribute to the paid leave program and will be able to apply for benefits. Non-unionized employees of the state, so managers, appointed officials, judges, legislators, we're all contributing and will be able to apply for benefits. Unionized employees of the state of Connecticut will have to collectively bargain to be included, but if they do so, they'll be part of the program. Employees of municipalities and local and regional boards of education are excluded right now, but if they're unionized employees collectively bargain to be included, then everyone, the union and non-union, would now be considered part of the program. As I mentioned, the fund is entirely funded by employee contributions. There is no employer match. It's entirely employee funded, and the contribution is 0.5% of the employee's wages, capped at the Social Security contribution limit. Because the statute says that the contributions are capped at the Social Security contribution limit, we define wages the same way as Social Security. So you would calculate the wages the same way you do for determining FICA, and then you take 0.5% out of that amount. It's employee funded, but the employer is the one who's handling the paychecks. So the employer has to take the deduction and then remit the deduction contributions to the authority with some basic wage information. We don't ask for a lot. As I said, that's done on a quarterly basis. The authority receives that contribution and validates the information, and the money is deposited into the paid leave trust. The paid leave trust is a dedicated account. It's not even considered state assets. It is not commingled with any other state funds. It is kept separate. It is actually managed by the Office of the State Treasurer, and it can only be used to administer the program and fund the benefits. Okay, so that's a little bit about the program. Let's talk about the laws that we will all be operating under. And I think it's important to define the terms. We talk about FMLA a lot. FMLA stands for Family and Medical Leave Act. but there are two FMLAs. There's a federal FMLA and a Connecticut FMLA. There's a bunch of other states have them too, but we'll focus on the federal and the Connecticut. Both laws allow eligible employees to take job-protected time away from work if they have certain qualifying conditions. Both laws state that the leave is unpaid, but that the employer may adopt policies that would provide income replacement during the leave. So some employers just continue to pay their employees their regular salary. They just do it. Many employers require or permit their employees to use their earned accruals, so their sick leave, their vacation, their other PTO, and say you're either required to use that while you're out or you're allowed to use that while you're out. But the leave itself is unpaid, and the accruals basically are a substitution. There are lots of discussions about revising the federal FMLA, but none of those have taken effect yet. Revisions to the Connecticut FMLA have passed, and they will take effect in January. So let's talk about that. If you are an employer with 75 or more employees, you've been working with Connecticut FMLA because it's been on the books since the 90s. But starting in January, the Connecticut FMLA will apply to employers with 1 or more employees. In order to be eligible for job protection under the existing law, the employee had to work at least 12 months and have worked for at least 1,000 hours in the 12 months immediately preceding the leave. But in January, that goes away, and employees will be eligible for job-protected leave after 3 months, and there will no longer be an hours worked requirement. The amount of leave changes too. Right now, it's a 16-week leave in a 24-month period, but that's going to change to a 12-week leave in a 12-month period. Now, there's something called military caregiver leave, which is when you have to take leave to care for a family member who's been injured in active duty. And that's been on the books since, I think, 2008 under the federal law, 2010 under Connecticut law. And that allows for 26 weeks of leave. So that'll still be available. Under the new Connecticut FMLA, there's also a right to 2 additional weeks of leave for a person who experiences incapacitation during pregnancy. The other change to the law that I think is important to focus on is that language that says the employer may permit or can require an employee to use accrued time while they're out on leave. Under the existing law, an employer could require the employee to exhaust all of their accruals. But as of January, while the employer can still require their workers to use their accrued time, if that's their policy, they have to allow the employee to hold on to at least 2 weeks of accrued PTO if the employee wants to do so. You can no longer require the employee to exhaust their PTO when they're out. Just take a quick look. Oh, great question. Someone is asking, can the 3 months of service be non-consecutive in order to be eligible for Connecticut FMLA starting in January? And the answer is yes. FMLA. There's also CTPL. We use CTPL to refer to Connecticut Paid Leave. So there's the Connecticut Paid Leave Act, the Connecticut Paid Leave Program, and the Connecticut Paid Leave Authority. The Connecticut Paid Leave Act is a Connecticut law, and it's intended to create a source of income replacement benefits for eligible employees who can't work for covered reasons. It does not provide job protection. So notwithstanding the reference to leave, we really focus on the paid part. We don't give people the right to take time off from work. We give people income replacement benefits if they have to be out of work. You might also hear about this as the PFML or paid family and medical leave. We're trying to get away from calling it PFML just because it creates confusion between FMLA and PFML. Too many similar letters. That's why we're really focusing on CTPL. Another question about both Connecticut FMLA and Connecticut Paid Leave, and that is, do part-time employees qualify? And yes, they do, because there's no hours worked requirement. A part-time worker could still qualify for job-protected leave. It's basically prorated to meet their schedule, and they could also qualify for income replacement benefits. Now, I told you for both FMLA and CTPL, you have to have a qualifying reason, and the qualifying reasons are basically the same. You can take leave and get money. If you're out because of your own serious health condition, you're receiving treatment or you're recovering. And the definition of serious health condition does include pregnancy and includes organ and bone marrow donation. You can also take leave and receive benefits if you are caring for a family member who has a serious health condition. This is called caregiver leave. Then there's the happy reason, which is bonding. So bonding with a newborn or newly placed adopted or foster child to spend time with them, get them acclimated to your family, create that emotional relationship. In cases of adoption and foster care, you can also use bonding leave to attend to some of those pre-placement activities like going to court or having to travel to pick up the child. As I mentioned, there's military caregiver leave, and there's also something called qualifying exigency leave. This is leave to attend to specific issues associated with a parent, spouse, or child's deployment in the military service. And then there's also a separate law in Connecticut called the Family Violence Leave Act that's been on the books for over a decade. And that says employees of employers with any size are entitled to take job-protected time away from work if they're directly experiencing family violence and need the time to receive treatment, counseling, to go to court, or to relocate. And that statute says an employer must provide at least 12 unpaid calendar days of leave to their employee. And the CTP paid leave says we will provide income replacement for those 12 days. Now, caregiver leave. I should tell you that with the exception of family violence, the other reasons, medical leave, caregiver leave, bonding leave, military caregiver leave, and qualifying exigency leave are also covered under federal FMLA. But caregiver leave is a lot broader under the Connecticut laws because it's available to take leave and receive benefits for your parent or your spouse, but also your son or daughter of any age. Whereas under federal FMLA, it has to be a minor child or someone who's 18 and over who has a disability as defined by the ADA, which causes that person to be unable to perform at least 3 activities of daily living. So federal FMLA is really limited. Connecticut FMLA and Connecticut Paid Leave Act allow for a lot more family members, including son or daughter of any age, sibling, grandparent, or grandchild, as well as an individual related to the employee by blood or affinity, whose close association the employee shows to be the equivalent of those family relationships. So what does that mean? Well, it's really a recognition that families come in all shapes and sizes. It's not the Ozzie and Harriet family anymore. And you could have family even without legal bonds. So it's going to be on a case-by-case basis. And you can ask the employee to provide you a writing that explains, yes, I have this relationship, this significant personal bond with this person, which is the equivalent of a relationship with a parent or a spouse or a sibling or etc. So, for example, maybe it's the aunt and uncle who rely on the employee for unpaid care and who the employee has been exceptionally close with their entire lives. In my family, my great aunt really took the place of my grandmother. We did her grocery shopping every week. When she got older, we did her laundry. She came to every event, every school concert, every Christmas, every birthday. And so when she was sick, we were the people who took care of her. Another example would be that unmarried significant other. Connecticut does not recognize common law marriages, but there are plenty of people who have a spouse-like relationship who have not gotten married. And now under Connecticut FMLA and Connecticut Paid Leave, that relationship is recognized. I see a couple other questions coming in, but I'm going to save those to the end just so we can keep focusing on the main materials. So just a couple of handy guides, eligibility and the entitlement, kind of make it easy if you need to have a quick reference. If you have 50 or more employees in a 75-mile radius, you are covered by federal FMLA. An employee is eligible for federal FMLA leave if they have been employed by their employer for at least 12 months and they've worked at least 1,250 hours in the 12 months immediately preceding the leave. As we've discussed, Connecticut FMLA will now, as of January, say that you are eligible for job protected leave once you've been employed by the employer for at least 3 months. For income replacement, we don't look at how long you've been employed. We look at how much money you've been earning. An employee has to earn at least $2,325 in their highest earning quarter when we look at the first 4 of the 5 most recently completed quarters. And we'll look at their earnings from all of their employers. If they've worked for multiple employers, we'll look at all of that. They also have to be either currently employed and working in Connecticut at the time they apply for benefits, or they have to show that they had been working in Connecticut during some point in time in the 12 weeks before they apply for benefits, or they have to show that they're a sole prop or self-employed individual residing in Connecticut who's opted to participate in the plan. Only sole props and self-employed individuals have to be residents of Connecticut. For everybody else, we just ask that they're working in Connecticut, regardless of where they live. And then how much do they get? Well, federal FMLA is 12 weeks in a 12-month period with that 26 weeks of leave for military caregiver. Connecticut FMLA will be 12 weeks in a 12-month period with that 26 weeks of leave for military caregiver. As we've talked about, the 12 days in a calendar year for family violence, and the 2 extra weeks for incapacity during pregnancy. There was a question about starting out in family violence leave, and then if they have another, if they have their own serious health condition, does it count for that? And so yes, a person who's experiencing family violence may also have a serious health condition. And so we would consider it traditional FMLA for the serious health condition, and then frankly, use the family violence if they have to go to court or for something else that's not covered under traditional FMLA. And then with Connecticut paid leave, income replacement is available for 12 weeks in a 12-month period for all the leave reasons. And that includes military caregiver. We don't have 26 weeks, you get 12 from us. As I noted, you can get 12 days for income replacement during family violence and the 2 extra weeks of income replacement for a person who is incapacitated during pregnancy. So, quick review of the entitlements. Let's talk about how they will be implemented. And I'm starting with Connecticut paid leave because we really have 2 parts. There's the contribution side, which I skipped over, and then we'll talk about claims. Contribution side of Connecticut paid leave is the money. The worker contributes the 0.5%. The employer remits that 0.5%. To do that, they have to create an account with us. We have over 120,000 employers registered with the authority, either directly or with their TPA who's registered for them. The employer has to deduct the 0.5% and then remit that money to the authority. The authority receives and reconciles the contributions. We'll process any over or under payments. And starting next year, we will start imposing penalties for non-compliance. We made the policy decision this year not to impose any financial penalties because it's a new program and our focus has been on making sure people understand what to do. But starting next year, we will impose financial penalties for non-compliance. The Connecticut DOL does not have a direct role in connection with Connecticut paid leave, but there's an indirect role based on their general wage and hour authority, which allows the DOL to authorize employers to take deductions from employees' paychecks. You can't just willy-nilly take a deduction unless it's required by statute. But this year, the DOL has used its authority to allow employers to take catch-up contributions if they were unable to start their deductions in January. That general authority to take catch-up deductions expired at the end of September. So you should not be taking more than 0.5% from your employees' wages for this purpose, unless you have specific authority from DOL to continue to take those catch-up deductions. Okay, and now we can talk about the claims. It is the worker's responsibility to submit their application. It's done by the worker, not by the employer. To do that, they will either call AFLAC, which is the third-party administrator that the authority has contracted with, or they can go to ctpleave.org and create their account, and they'll be prompted as to how to submit their application online. They have to provide us with supporting documentation, and they have to give us additional information so we know when they're actually out, and they need to let us know if they're receiving any other sources of money. By statute, they do have to notify their employer if they're applying to us for income replacement benefits. We tell workers they have to notify their employer, but then we verify by making the employee give the employer an employment verification form. That form is a page and a half long, and we ask the employers to complete it and submit it back to the authority. It basically contains information that we can't get anywhere else, like information about the employee's schedule and sources of income. We may ask the employer to validate information about the absences or other sources of income beyond the employment verification form, but we're hoping the form will cover most of the situations. The worker needs to know what the employer is going to require with regard to their paid time off. Are they going to be required to use it? Are they allowed to use it? Does the employer offer short-term disability insurance? So the employer does need to let the employee know what those policies are. And of course, as with all these laws, you can't discriminate or retaliate against a worker because they have applied to us for benefits. It's not the same as giving them job protection, but it just means you can't say, oh, you applied for benefits, I don't like you, you're out of here. The authority will determine eligibility, will review supporting documentation and approve or deny the claim. We'll calculate and pay benefits. We have to monitor the claims. If we deny claims, there is an opportunity to request reconsideration. We will investigate potential fraud, and we have the authority to impose penalties as appropriate. As I mentioned, we have contracted with AFLAC to help us with this. They're an existing, well-respected insurer who sort of ready to go to stand up to help us with this. The Connecticut Department of Labor will hear appeals relating to denials of claims, and they can also hear appeals relating to any penalties that we impose. All right, so what does this look like? Well, as I said, the worker submits the claim. They can call AFLAC or go to our website and create their account and submit the claim. We have a checklist that they have to complete, and the documentation they have to provide really depends on the reason for the claim. Different form if it's caregiver leave versus their own serious health condition. They tell us how long they're going to be out and how much income replacement they're looking for, and if there are other sources of income. AFLAC will determine eligibility by validating their earnings through DOL data as well as other documentation as necessary, and will validate that they work for a covered employer. If a worker is not eligible, say they work for an employer with a private plan, we'll let them know that they have to go to the private plan. Or if they haven't earned the 2325, we'll let them know they're not eligible. If they're eligible, we will continue on the process to review their documentation and determine if the claim is approved or denied. If the claim is approved, we'll calculate benefits, again using DOL data as well as other sources of information about the worker's wages and whether there are any offsets. And we'll issue the benefit payments. We'll issue the payments either through electronic transfer or stored value cards, basically debit cards. The plan is to issue the benefits each Tuesday. And we say here on the slide, it's 2 weeks in arrears. Technically, it's like 9 or 10 days in arrears. So for example, for the benefits that will relate to the week of January 2nd through January 8th, we would issue those on the 18th. And then they get issued every week thereafter. The worker has to let us know if there are any changes, if they're going to be out longer, if they're going to go back to work sooner. And particularly with intermittent leave, we do require sort of ongoing information from the employee about when they're actually out. The benefits are set in statute. So if a worker earns less than or equal to minimum wage times 40, their benefit amount will be 95% of their base weekly earnings. And base weekly earnings are determined by looking at the highest 2 quarters, looking at the first 4 of the 5 most recently completed quarters, and dividing that by 26. If their base weekly earnings are more than Connecticut minimum wage times 40, look at 95% of 40 times the Connecticut minimum wage, plus 60% of the difference between their base weekly earnings and the Connecticut minimum wage. However, in all situations, the total benefit is capped at 60 times the Connecticut minimum wage. So just like their contributions are capped, their benefits are also capped. So what will this look like? Here, worker A earns 40 times, basically earns the minimum wage, and they work 40 hours a week, so their benefits would be 95%. Someone who's earning $520 would get $494 in benefits. Someone who earns more than the Connecticut minimum wage will get a little bit more in benefits, 60% of the difference. So worker B, who earns $13.50 an hour, would actually get $506 in benefits compared to worker A, who got $494. We get a lot of questions about the interaction between the Connecticut paid leave benefits and employer-provided time off. So there are a couple of things that dictate how we can respond. First, our statute says that an employee can receive employer-provided benefits at the same time as they're receiving Connecticut paid leave benefits. So it's possible. Connecticut FMLA says the employer may require or permit the employee to use their PTO while they're out on FMLA. However, they have to be allowed to hold on to at least 2 weeks. And then you think about the fact that most short-term disability insurance policies say they're a payer of last resort. I can't say that they all say that. You have to look at your own policy to see what it actually says. But most of them do say they're the payer of last resort and that an employee has to use their employer-provided accruals or state benefits before they can access the short-term disability benefits. So those are sort of the 3 legs of this stool. So what does this mean in practice? Well, a worker who has no PTO, that makes it easy. When they go out on leave, they apply it to us for benefits, and their benefits will start at the same time that their leave starts. On the other hand, you may have an employer who requires their employees to use their accruals, and you have an employee who has tons of accruals on the books. If they have enough accruals to cover their full leave, even with the whole 2 weeks held in reserve, then the worker doesn't need to apply to us for benefits. Their entitlement under CTPL is not touched at all. So if they are out for 2 weeks and the employer covers those 2 weeks, they still have 12 weeks of income replacement benefits available to them for when they need it from us. All right, so that's no employer benefits, all employer benefits. A lot of people will be somewhere in the middle. Maybe they have to use their employer-provided accruals, but they don't have enough to cover their full leave. So if the PTO covers a day's wages, they don't use CTPL benefits for that day. They'll start receiving the CTPL benefits as soon as they've used up the employer-provided allotment. So employees out for 4 weeks, they have enough accruals. The employer says you have to use accruals for your first 2 weeks. Great. Their leave starts on January 1st. They receive accruals from their employer for the first 2 weeks, and then they start getting benefits from the authority at the beginning of week 3. Then we have people who maybe the policy says, we, the employer, will cover you at 50% of your wages. So in that situation, the leave starts on January 1st. The employer provides 50% of their wages on January 1st, and CTPL benefits will also start on January 1st. But in that situation, we have to look and make sure that what the employer is providing plus what we provide does not exceed 100% of the employee's regular wages. So we ask about what you're doing, what your policy is in that employment verification form, so we can react accordingly. We're telling workers that, look, if you want to figure out what kind of benefits you'll get from us, you need to find out from your employer if the employer will require or permit them to use their PTO, and if there are any rules, such as you can only use your sick leave for your own serious health condition and not caregiver, for example. And if you offer a short-term disability policy and what the policy says. So use this time before January to make sure you know what your policies are and make sure you tell your employees what they are. All right, Connecticut Paid Leave does not have a whole lot of involvement with the employers. We ask about the schedule, we ask you what your policies are going to be, but kind of leave you alone. That's not the case for FMLA. FMLA, that is really primarily between the worker and the employer. So again, the worker will now tell the employer that they need to take time away from work, and they should do so in a timely fashion. If you require them to complete an application, then they have to complete the application and give you supporting documentation. And they do have to comply with your attendance and call-in policies. So you should probably have a call-in policy and an attendance policy, and let your employees know what it is. If you have at least 50 employees, you do have to post the federal FMLA poster. We are working to create a poster that is not yet mandatory. It will become mandatory in July of 2022, but that will be on our website if you want to start getting that out early. But as the employer, you do have to process your employees' leave requests, monitor their usage, and manage their return to work because it's job-protected leave. They will come back. And of course, refrain from discrimination or retaliation. So the Connecticut Paid Leave Authority really has no actual responsibilities with regard to FMLA, but we've learned that it's really hard to explain Connecticut Paid Leave without talking about FMLA. So this is why we include this information as part of our training, so we can explain the differences and kind of where the responsibilities lie. On the other hand, the Connecticut Department of Labor is the agency responsible for enforcing Connecticut FMLA. They will be promulgating revised regulations. Kind of check their website out frequently. And they are providing some guidance. For example, they have on their website information about how to deal with that conversion of 16 weeks in a 2-year period to 12 weeks in a 12-month period. And they will investigate complaints and appeals relating to Connecticut FMLA. What does the job-protected leave process look like for you? Well, the worker has to tell you that they need time off from work for a covered reason. They don't have to say, I need FMLA. They might say, oh yeah, I just found out that dad needs hip replacement. I'm going to need time off. Or I got hit by a bus on my way home from work. I'm not going to be in for a while. They should tell you 30 days in advance if the need for leave is foreseeable. But if the need for leave is not foreseeable, they have to tell you as soon as practicable. You're not going to be the one they call from the ambulance, but they should be telling you pretty soon after they get themselves situated. You, as the employer, determine if the worker is eligible for Connecticut FMLA and federal FMLA if you're covered. And you notify the employee if they're eligible and if they need to provide you with any additional documentation. You have 5 business days to notify the worker of their eligibility. And you also have to provide them something called a Notice of Rights and Responsibilities. Federal DOL has a form that you can use. Connecticut DOL is working to adapt that form to apply to Connecticut law. The decision about eligibility is not leave approval. It's just, yes, you've worked for us for 3 months. We need more information. So the worker has to give you that more information. It's a med cert, maybe it's adoption documents, maybe it's military records. It depends on the reason for leave. They have to give it to you. You have to give them at least 15 calendar days to get the documentation to you. If the worker tells you that they're having trouble, you are required to give them additional time. But they have to tell you that they're having trouble. They have to stay in communication with you. Once you've received the documentation, you have 5 business days to review it and approve or deny the leave. So you have to notify them if the leave is approved under FMLA, Connecticut, federal, whatever you're covered by. When you approve it, you have to tell them if they're required or permitted to use their accruals, tell them if they have to report in, tell them if they need a fitness for duty. You put all of that in writing. And if you're denying it, you tell them that it's being denied and give them a reason. If the employee knows that the leave is occurring and they've done all of this ahead of time, this will all be squared away before they even go out on leave. But they need to tell you when they actually go out on leave. And they can't just say, oh, I don't feel well today. Once they're approved, they have to use the FMLA. Hey, I'm in labor. My FMLA is starting now. And then you want to track that leave usage to make sure that the worker is not exceeding the 12-week entitlement. If you're covered by federal FMLA and Connecticut FMLA, you need to track both. And frankly, you need to track them separately because a person might be eligible for Connecticut FMLA after 3 months and not eligible for federal until 12 months. And so they will have used up one before they even touch the other. Now, FMLA is all about job protection. So the leave is job protected. They are entitled to return to their same job when they come back from leave. Same job, same terms and conditions. If they're a first shift worker, you can't say, okay, well, now you're going to work second shift. Say you got Bob from Account Temps. I don't know if they still have those ads, but that was a big advertising promotion a couple of years ago. Bob from Account Temps came in and Bob was great. Maybe you got Bob from Account Temps and you realize that Bob is so much better than Joe. Doesn't matter. Joe gets the job when he's back. You can't insist that an employee be 100% fit for duty or totally recovered. And that's because an employee may have rights under the Americans with Disabilities Act or the Connecticut Fair Employment Practices Act. This is really when you're talking about an employee out for their own serious health condition. You have to consider if they're entitled to reasonable accommodations to help them perform the essential functions of their duties. All right, I'm not going to lie. FMLA is not the easiest thing in the world. It requires attention to details. So just sort of confront it, accept it. It'll make your life easier if you're not fighting that part of it. The number one thing to deal with, I think, in my experience, to understand FMLA and to really do it right is you have to manage your workers' absences. So if you have attendance policies and call-in policies, enforce them and make sure that your supervisors are telling your HR or your operations people when workers are out so that you can enforce them and do the notices you're supposed to do. When you're dealing with someone's own serious health condition or caregiver leave, you're entitled to a med cert, and you are entitled to a complete and sufficient med cert that gives you information that enables you to determine it is a serious health condition and how much time they need. So insist on those. You're not entitled to a diagnosis and you're not entitled to the employee's entire medical history, but you are entitled to information to help you validate that, yes, this is a serious health condition. I saw in the questions that someone asked if there's a definition for a serious health condition. And actually, if you go to our website, we have it defined there. It includes chronic conditions for which someone sees a doctor at least 2 times a year. It includes incapacity plus treatment, where you see a doctor within the first 5 days of being sick, and then the doctor requires the employee to come back within 30 days or puts them on some sort of physical therapy or prescription medication. It includes pregnancy. It includes like broken legs, surgery, overnight stays in a hospital. The whole list is on our website. Intermittent leaves. So they can be challenging because a lot of times the absences are unforeseen. So you just want to make sure you understand the likely frequency and duration of the absences. You can't get a guarantee, but you can get estimates. And you want to manage it. You want to make sure that you know when the absence is connected to the leave. Fluctuating work weeks can also be challenging. You just need to understand that if someone has a fluctuating work week, that you look at their average work week. So that might include overtime. But if someone can't do FMLA, or sorry, can't work because of their FMLA condition, you would deduct that missed overtime from their entitlement. And as I mentioned, you might have multiple leave laws to pay attention to: Connecticut FMLA, federal FMLA, and other laws. So you want to just pay attention to all of them. One thing to know is that in all circumstances, it is the employer's right and responsibility to designate time off that qualifies under FMLA as FMLA, even if the worker does not ask for it. So the worker's eligible, the leave reason qualifies, you want to track it as FMLA and start deducting their entitlement. This protects you because you're giving the employee their rights, and the employee can't come back and say they were denied their rights. It also protects you because you can manage the 12 weeks that way. The only way you can manage the 12 weeks is if you're counting them, and you let the employee know that you're doing so. This also protects the employee because it makes sure that they get the job protection they're entitled to, and that they understand what leave or what absences are covered. Candidly, this slide is mostly here as a reminder to me to make sure I've ticked all the boxes. We've talked about ADA and Connecticut Fair Employment Practices Act. There's also the Pregnancy Disability Act, which says you can't discriminate against workers who are pregnant, and leave may be a reasonable accommodation. Then there's workers' comp. So as you know, workers' comp means that someone has been injured on the job. They get medical benefits through workers' comp, but they also get income replacement benefits through workers' comp and some job protection. A worker who's receiving income replacement benefits through workers' comp cannot also receive Connecticut paid leave benefits for that same absence. It's an either or. All right, before we get into the questions, let me just share with you that we've got all sorts of information on our website. We have toolkits, we have an HR toolkit, we have a small business toolkit, we have posters, rack cards, mailers, fact sheets. We also have YouTube videos, as well as videos on the website. There's frequently asked questions that we're updating all the time. And if you can't find the information you need, you can always submit a question to us through the Contact Us button on the portal. We have a relationship with United Way 211, and they help us respond to those questions. And if people ask for a phone call, we will schedule a phone call back. We do not have a phone number that you can call in directly, but you can submit your question to us and ask for a call back, and we will schedule time to talk with you. CTPLeave.org. Make us a favorite, bookmark us on your computer so that you can go back, because as I said, we are updating the content really all the time. We just unveiled a prepare to file claims page, as well as a page specifically for businesses, small employers. All right, let me look at the questions that have been coming in, make sure that I've answered them.
Thank you, Erin. I've been trying to go through them as they come in. And for folks that are submitting questions in the chat, we are not monitoring the chat. Please use the QA. So I've left a few in here for you to answer. Erin, would you like me to read through those with you?
That's okay. I'll go ahead and read them, and then I can answer as we go. Thank you so much,
Great,
Amber.
thank you.
So the first question is, will CT paid leave benefits be paid based on the wage rate on the first day of absence, or will the benefit amount change if the wage rate changes during the leave? Great question. The benefits are based on actually the highest income quarters when we look at the first 4 of the 5 most recently completed quarters. So it's actually based on wages that they received between 4 and 16 months ago. So that would be the amount of the benefits. The only time we would expect the benefits to change during the life of leave would be if there are offsets that were not applicable at the beginning, but maybe later on they're receiving income, and so that might reduce the benefit amount. Or the Connecticut minimum wage is going to be changing over the next couple of years, and that does impact the benefit amount because, as I mentioned, for example, benefits are capped at 60 times the Connecticut minimum wage. So if the minimum wage goes up, you have to reassess and make sure that the cap is taken into consideration. So we may see an increase in that situation because the minimum wage rate went up. Question came in, what happens if the employee requests paid leave, but the employer has not contributed 0.5%? Well, we will still process the employee's paid leave request, but that will trigger a compliance report for the employer, and the employer will be contacted by our contribution team and maybe assess penalties for the fact that they haven't been contributing. That's assuming it's a covered employer. If an employee, say an employee of a private elementary or secondary school applies, they're not a covered employer, we would notify them that you can't come to the paid leave authority because you don't work for a covered employer. Question, can an employee use short-term disability benefits and CTPL for the same leave? So our statute does not prohibit that as long as the total amount does not exceed 100% of the employee's regular wages. But you do need to look at your insurance policy to see what the insurance policy says. Will the website offer options to private carriers by showing who covers the employer? Also, can private carriers reach out to verify wage information from Connecticut? No. At this point in time, we are not planning on having our website post information as to which employers have approved private plans or who they're covered by. We obviously are tracking that ourselves, but we're not at this point in time planning on making that public, although that's something we can consider. Private carriers have a contractual relationship with the employer that they're covering, and they'll need to get wage information from the employer. There's no entitlement to get wage information from Connecticut. Another question about short-term disability. If you've got short-term disability, do you apply for paid leave first or the policy? You need to look at the policy. If an employer is not deducting the 0.5%, what do they do? How do they make up their missed contributions? And where do those missing contributions come from? Well, an employer that has not been compliant and has not been taking the 0.5% deductions from January has basically two options. They can try to get permission from Connecticut Department of Labor to take additional deductions beyond the 0.5% to catch up. They'd have to have a really good reason. I'm just going to let you know that. But that's something they could ask DOL for permission. If DOL says no, then the employer is going to be responsible for making up those missing contributions itself. It's as opposed to taking it from the employee's wages. And the employer will have to deal with the tax consequences associated with taking on that responsibility. Great question. Is there an elimination period or do the benefits start from day one? We do not have an elimination period. So let's go back to that scenario where someone does not have PTO or their employer doesn't require them to use it. So they go out on January 2nd for their leave. They're covered under Connecticut paid leave. Our benefits will cover them for January 2nd going forward. Just a question about Connecticut FMLA. Is that still offering 16 weeks within a 12-month period? No, it's 12 weeks. So Connecticut FMLA is changing to a 12-week entitlement in a 12-month period. And as I mentioned, the Connecticut DOL has some guidance on its website about how to convert 16 weeks in a 2-year period to 12 weeks in a 12-month period. Will Connecticut DOL be providing a sample policy for employers? I have not seen, and they have not heard them, we talk with them quite a lot, and I have not heard them discuss providing a sample FMLA policy. They are updating the regulations, and they are providing some proposed forms to be used, but I don't think, it's not to my knowledge, they don't have a draft policy. If an employee refuses to submit a claim for leave, and the leave meets both FMLA and Connecticut FMLA, can the employer request to deduct time from their benefit period maximum for the time that was taken? Okay. If they refuse to submit a claim to the paid leave authority, there's nothing the employer can do about that. That is totally the employee's choice, whether or not to apply to the authority. And if the employee does not apply to the authority for income replacement benefits while they're out, then they won't get the benefits from us and they'll save those for something else. On the other hand, when you're talking about the job protection under FMLA, as I mentioned, if the employer has knowledge that the reason for leave is covered and the employee is eligible, they can designate the time off as FMLA and start deducting the job protection. But they have to notify the employee that they're doing that. All in all, employees are not entitled to any more than 100% of their pay. Absolutely correct. Does Connecticut FMLA require employer to continue all benefits during the leave? And does that mean PTO accruals have to continue? Great question. So, no, Connecticut FMLA does not require the employer to continue benefits during the leave. Federal FMLA says that an employee who's out on federal FMLA job protected leave, the employer has to continue their health insurance while they're out on leave, but they can require the employee to continue to pay its share. So if the employee is out on federal or federal state combo, you would carry forward with the insurance. But if it's just Connecticut FMLA, you're not legally required to keep them on your insurance. You may choose to, and you can do benefits billing, but you're not required to. For both federal FMLA and Connecticut FMLA, PTO accrual is not mandated. They say you just have to treat the employee the same way you treat them if they're out on other types of leave. So if you say, for example, state of Connecticut says you don't get your PTO for the month if you were out more than 5 days of unpaid leave the previous month. That's perfectly permissible as long as you apply it for all types of leave and don't have a specific policy just for FMLA leave. Under FMLA, does bonding leave have to be taken within 12 months of the birth, adoption, or foster placement? This is someone who knows their federal FMLA. Yes, Connecticut FMLA has the same rule. Bonding can be taken anytime in the 12 months, and they'll get income replacement if they're out anytime in the 12 months. Question about affinity relationships. What documentation is needed? So Connecticut DOL has reported that it's a simple writing that needs to be, that an employer can ask for a simple writing where the employee describes the affinity relationship. And at the authority, we've actually created a form that we're going to be using. It'll be on our website soon. Feel free to take that, use that as well. This is similar to federal FMLA requirements relating to someone who stands in the place of a parent, which has always been covered. So we're basically just adapting that. Are seasonal employees eligible for Connecticut paid leave? Yes. So, and a seasonal employee could be eligible for Connecticut FMLA if they've worked at least 3 months. For Connecticut paid leave, we look at how many their earnings, right? So if someone earned 23-25, their highest earning quarter, and they're either currently employed or had been employed in the 12 weeks before applying to us, they could get benefits from us. And so seasonal employees could meet that definition. Do Connecticut FMLA and federal FMLA run concurrently if the employee is eligible for both? Yes, provided the reason for leave is covered by both. So your own serious health condition, that would run concurrently. Connecticut FMLA allows you to take caregiver leave for your siblings. Federal FMLA does not. So someone who's out on caregiver leave for their sibling would only be tracking down their Connecticut FMLA, and they would not attach to their federal. Are there resources for employers to hire, train, supervise, and pay new staff to replace the staff who are out on leave? So there's no sort of fund that would sort of pay for that, but there are a couple of things. One, I would encourage you to check out a webinar that the Connecticut SBDC. Amber, do you remember what Connecticut Small Business Consortium, Small Business Development? Do you remember what it's called? I'm blanking.
I'm talking and I have my mic off. Yes, it's the Small Business Development Center.
Thank you. So the Connecticut Small Business Development Center is an organization that sort of operates out of UConn and with the Small Business Administration. And we've partnered with them. They're going to be doing some webinars to talk about things like planning for these new laws from an operational perspective, cross-training and the like. So we'll be posting those webinars on our website. I encourage you to check them out. So there's some things you can do in advance. Also, I can let you know that if you have to hire a temporary worker or a worker to replace someone who's out on leave, and then you let that person go when the first person comes back, that will not result in an unemployment charge against your company. So there is that entitlement or that protection for you. So what if we have an employee on leave now expected to go through December? We've not said it's FMLA because they're not yet covered. Will the employee have 12 weeks of job protected leave as of January 1st if she does not return? Can we count that time as FMLA now? No, you cannot count time as FMLA if you're not covered by FMLA right now. So you would have the employee say they are out because we're getting a lot of these. Say they're out because they're going to have a baby in December. They may have the entitlement to take maternity leave through the Connecticut Fair Employment Practices Act and the Connecticut Pregnancy Disability Act, Pregnancy Non-Discrimination Act. So they're entitled to take that maternity leave, but it doesn't count under Connecticut FMLA because you're not covered by Connecticut FMLA yet. Starting in January, you will be, so they would have the 12 weeks then. New question, if an employee only qualifies for Connecticut FMLA and use 12 weeks, then 9 months later, they need additional leave, and that leave is eligible under federal FMLA. Do they get leave under federal FMLA at that time? Yes, they do, assuming they're eligible. Now remember, for federal FMLA, there is an hours worked requirement. So someone who's been out for a long period of time may not meet that hours worked requirement, but it is possible that someone could use their Connecticut FMLA and then their federal FMLA later. So that's why I say it's really important to look and make sure if you're covered under both laws, to check to see if the employee is eligible under both laws and if the reason for leave counts under both laws. And if all of those things say yes, you run them concurrently and you deduct. If there's a no, they're not eligible for federal, but they are eligible for Connecticut, you track the Connecticut so that you can keep your eye on that and then accept that the federal FMLA will also kick in. Will Connecticut Leave look at leave history to identify attempts to abuse taking leave? Okay, remember, we only do income replacement. We don't do leave, but yes, we will be paying attention to potential abuse. It's one of the things that having a well-established partner is going to really help us with. And for employers, there are things you can do to kind of mitigate potential for abuse, including making sure you have complete and sufficient med certs and making sure you're tracking the time. Connecticut FMLA is unpaid, correct? Yes, thank you for knowing that. In order to get paid, they must apply to CTPL. Mostly yes. In order to get paid, you have to look at the employer policy. They require or permit the employee to use PTO. And then they could also apply to Connecticut paid leave to get paid. If an employer has a short-term disability policy that pays 100%, does that mean there's no need to apply to CTFML? CTFML is for the job protected leave. So if an employee needs to be out of work for a qualifying reason, they really should apply to their employer for the Connecticut FMLA because that's what gives them job protection. And if you know that they're out for a covered reason and they're eligible, you want to call it FMLA. If you offer short-term disability that pays 100%, you need to look at the policy to see if they're the payer of last resort or if they're the payer of the first payer. If they're payer of last resort, the insurance company is going to tell the employee to use their other entitlements first. But if they're the first payer, then you have to look at what reasons are covered. A lot of short-term disability policies cover only your own serious health condition, maybe a little bit of bonding time, but they don't cover caregiver or military or family violence. If an employee goes out under the 16 weeks of Connecticut FMLA, say in November or December, and then the benefit changes to 12 weeks in January, what is their entitlement? Go to ct.gov, type in Department of Labor, and type in FMLA on their website. They have guidance. I don't want to paraphrase it for you because it's pretty detailed. They give a lot of examples, but you do have to kind of read it a couple of times, but they do give you guidance, and I really strongly encourage you to read that. Great question. Fathers must be allowed to take 12 weeks of FMLA. Yes. If a father wants to bond with their child, they are entitled to do that, and they are entitled to up to 12 weeks of Connecticut FMLA and federal FMLA. Bonding is available to both parents. There are rules relating to if both parents work for the same employer, the employer might require them to share the time, so they don't get 12 each, they get to share the 12. But there is no, employers cannot say, mothers can take 12 weeks, but fathers can only take 2. That you have to provide it, the unpaid child protected leave under Connecticut and federal FMLA equally. Is a temporary employee eligible for Connecticut paid leave? Yes, potentially. So Connecticut paid leave, we look at whether they've got the appropriate earnings, the 23-25 in the first 4 quarters, so their highest earning quarter in the first 4 of the 5 most recently completed quarters. So if they're eligible and they're working, they could get benefits from us. A temporary employee may also be entitled to job protected leave. When you're talking about temps, you do have to think about who's actually the employer, whether it's the temp agency or you. So that's a conversation to have. There is no carve out for temporary employees, just like seasonal workers. We can tell you that the legislature really wanted to make sure that all workers, or as many workers as possible, would be covered by these protections. All right, I'm seeing it is well after 9, so I really appreciate your patience getting through these questions. The this seminar has been recorded, and we will post the recording on the events page on our website for this day. So if you want to check out the recording, it'll be up later. And as Amber said, we will share with you the slide deck. If you have additional questions that we didn't get a chance to answer, please check out ctpleave.org. Check out the FAQs. And if you still have questions, go to the Contact Us page and submit your question there. Thank you so much for your time today.